Hello everyone, welcome back to day 22 of Polity Daily Drill. Let's begin. First question. Consider the following statements about PAC, that is the Public Accounts Committee of the Parliament. Now please remember that PAC or the Committee on Public Accounts is not mentioned in the Constitution but under Lok Sabha rules. In fact, parliamentary committees are mentioned in the Lok Sabha and the Rajya Sabha rules. So PAC is under Rule 308 of the Lok Sabha rules. Now, first statement, it was first set up in 1921 under the provisions of Government of India Act 1919. This is correct. In fact, PAC is the oldest committee in the country. It was first set up in 1921. Second one, it has currently 22 members, all from Lok Sabha. Yes, PAC does have 22 members, but not all from Lok Sabha because it is a joint committee and not a select committee. What is a select committee? A select committee is a committee which has MPs from one house only. A very good example of a select committee is the Estimates Committee of the Parliament, which has 30 MPs all from Lok Sabha. PAC is a joint committee, which means it has 15 MPs from Lok Sabha and 7 MPs from Rajya Sabha. In fact, till 1954, PAC did not have MPs from Rajya Sabha, only from Lok Sabha. It is only after 1955 or 1955 onwards that they had MPs from Rajya Sabha as well. So second statement is actually wrong. Third one, its members are chosen according to the principle of proportional representation is correct. And the fourth one, the chairman of the committee is invariably from the opposition is also correct. But again, till 1966, the chairperson of this committee used to be from the ruling party. I know makes no sense because the functioning of PAC is to evaluate the expenditure of the government, look into reports of the CAG. Why should the chairperson be from the ruling party? But before 1950, the chairperson was the finance minister, even more hilarious. But thankfully, order has been restored. 1967 onwards, the chairperson of the PAC comes from the opposition party. So 3 statements are correct. How many statements are correct? C. Only 3 is the right answer. Moving on to question number 2. It can be moved against an individual minister, a group of ministers, as well as the entire council of ministers. Interesting. So it can be moved against a single minister, a group of ministers, or the entire council of ministers. It means an expression of strong disapproval or harsh criticism. It can be moved in the lower house of the parliament or in a state assembly in India. So which of the following motions is described in the paragraph given above? It cannot be an NCM. Why? Because NCM is moved against the entire government. It cannot be a privilege motion because a privilege motion can be moved against any MP, not just ministers, and in either house. And since this motion is again being moved only in the lower house, this would mean that calling attention also is out of contention. Censure motion is the right answer. And as you would see, what is a censure motion? It just means a strong disapproval, harsh criticism, or as we call, what? Reprimand. So it just means that the house has collectively scolded the concerned minister or the group of ministers if at all this motion is passed. Right answer is C, censure motion. Now question number 3. Consider the following statements with respect to Schedule 6 areas. Schedule 6 areas, not Schedule 5. Schedule 6 areas are those autonomous districts the 10 autonomous districts in 4 northeastern states. Which are those 4 states? We have Assam, we have Meghalaya, then Mizoram and Tripura. So in these 4 states, we have certain districts called autonomous districts, and for each such district, we have an independent body called ADC. It's actually called DC, a district council, but commonly known as an autonomous district council or ADC. Now let's see. First statement, laws made by parliament can be modified in their application to Mizoram by the governor. Now just to clarify, the governors and the president can modify laws made either by the parliament or the state legislature in the application to these states. Now, when it comes to a state like Assam, it is the governor who makes modifications in the laws made either by the parliament or by the state legislature. When it comes to a state like Meghalaya, it is the president who makes modifications in the laws, either laws made by the state assembly or by the parliament. For Mizoram and Tripura collectively, you will see that if the state legislature makes a law, then the governors can modify the laws, and if the parliament has made a law, then the president can modify those laws. So this is the whole scheme of things. Now let's look at the statements. Laws made by parliament can be modified in their application to Mizoram. Laws made by parliament can be modified by the president, not by the governor. One is wrong. Number 2, laws made by the state legislature of Assam can be modified in their application by the president. So we know for Assam it's only the governor. This is also wrong, incorrect. Number 3, governors of these states have no powers whatsoever to cancel or suspend laws made by the ADCs under any circumstance without consulting them. Now this is incorrect. Why? Because if at any point of time the ADCs, the autonomous district councils, make laws, rules, regulations, etc., which either threaten the unity, integrity of the country, or are prejudicial to public order, hamper public order, then the governors can cancel, annul those laws, right? So 3 is also incorrect, because the governors do have powers to suspend or cancel those laws, rules, regulations, etc. So all 3 statements are incorrect. Now how many statements are incorrect? Right answer is C, all 3. Moving on to question number 4. The provision of anti-defection law, that is 10th schedule of the Indian Constitution, does not apply to. So it does not apply to members of the House who are a part of Council of Ministers. So does the ADL provision apply to ministers? Yes, of course it does. It has no relevance to whether you are a minister or a private member. Then members who have not been elected as the leader of the legislative party. Now see, for various parties which have their MPs in the House, MLAs in the House, somebody is chosen as a leader of the party. All other MPs who are not the leaders of their party, ADL applies to them as well. So this is also wrong. C, split in the original political party. Now anti-defection law, the 10th schedule, does not apply to splits. It used to, but now splits are not recognized by ADL. We only recognize mergers. And if a political party merges with some other political party, and this merger should mean at least 2/3 of its members, the legislators merge, only then will they not be disqualified. So it is basically an exception, right? So ADL does not apply on splits. The exception part does not apply on splits. So C is the right answer. Let's look at D as well. A member giving up the membership of his original political party voluntarily. Of course, ADL applies to these people also. If you give up your membership, then you might be disqualified depending on the decision of the presiding officer. So, right answer is C. And the last question for today. Consider the following statements regarding the features of Indian secularism. 1. It advocates mutual exclusion of state and religion in order to protect individual freedom. Mutual exclusion. In fact, secularism does depend on this very concept. The basis of secularism is what? Strict separation between religion and state. However, in India, Article 25, Clause 2, Subclause B, it very clearly mentions that the state can make laws to provide for what? To provide for social welfare and reform in your religion. So in India, there is no mutual exclusivity. Why? Because state will interfere and modify your practices if they are found to be derogatory of other rights or of public order or health or morality. That is why we say that Indian secularism is based on the idea of principled intervention, based on certain principles of upholding rights of people. The state can interfere. So one is wrong. Second one, it forbids state from providing any type of financial aid to any specific religious community. This is also wrong. Article 27 clearly says, and there is a Supreme Court judgment, that if a small amount of money collected by the government in the form of taxes is spent to provide convenience to any religion, it does not violate the constitution. Praful Goradia case of 2011. 2 is also wrong. 3. A single standard civil law is employed in delivering justice regardless of religious affiliation. This is wrong. Though Article 44 expects that we should have a UCC, a Uniform Civil Code, but we also provide for the guarantee and promise under Article 25 and 26 to practice your religion. And so far, there is no UCC across the country. So 3 is also wrong. And the fourth one, it prevents the state from discriminating against any citizen on the grounds of religion. Yes, this is correct. So this is Indian secularism based on principled intervention and separation. Separation of the state and religion, but only till it does not violate somebody's rights, and of course non-discrimination against people on the grounds of religion. So how many statements are correct? Only one. A is the right answer. This brings us to an end of our discussion for today. Let's meet tomorrow. Till then, that is all for me. Jai Hind.